Welcome back to my channel and welcome back to Daily Thoughts. Please like, share, and subscribe to my channel. And don't forget to hit that bell so you are notified of all my upcoming content. Today, my Daily Thoughts is on the death of the Voting Rights Act. How one case has changed everything. So now, let's get into my Daily Thoughts. In 1965, American citizens marched across the Edmund Pettus Bridge in Selma, Alabama, to demand the right to vote. Their sacrifice led to the Voting Rights Act, VRA, famously called the crown jewel of the civil rights movement. For 60 years, it was the shield protecting minority voters from discrimination. But today, that shield is shattered. On April 29, 2026, the Supreme Court delivered what legal scholars are calling the wrecking ball to what remained of the law. The ruling in LouisianaVCallais didn't just tweak the rules, it rewrote the very soul of the Voting Rights Act. As Justice Elena Kagan put it in her dissent, the majority left Section 2 all but a dead letter. Today, I'm going to break down how the Supreme Court gutted Section 2 of the VRA, why it renders the law virtually meaningless, and why 28 active lawsuits defending minority voting rights just evaporated overnight. This is the story of the dismantling of American voting rights. To understand what just happened, we need to revisit the architecture of the Voting Rights Act. Originally, the VRA had two main pillars. The first pillar was Section 5, and this required states with a history of racism, mostly in the South, to get pre-clearance from the federal government before changing any voting law. It was preventative policing. But in 2013, the Supreme Court killed Section 5 in Shelby County versus Holder. Chief Justice John Roberts said the formula for determining which states were racist was outdated. After that, the second pillar, Section 2, became the last line of defense. Section 2 was reactive. It allowed private citizens and the DOJ to sue after a map was drawn, arguing that diluted minority voting power. And crucially, until this last Supreme Court ruling, you did not have to prove a racist intent to win. You only had to prove a racist result. This is called the results test, and it was the only tool left to stop racial gerrymandering until the Supreme Court took it away. The death blow came in the case of LouisianaVCallais. Here's the backstory. Louisiana had a messy redistricting fight. After years of litigation, the state created a second majority black congressional district, a district shaped like a snake, as critics called it, stretching over 200 miles to connect black communities in Baton Rouge to Shreveport. A lower court ruled this map was necessary under Section 2 to give black voters a fair shot. But Republicans and the Trump administration appealed to the Supreme Court, and on April 29, the 6-3 conservative majority ruled in favor of Louisiana. Host Justice Samuel Alito wrote the majority opinion. His argument is a radical shift in constitutional interpretation. Alito said that Section 2 does not exist to fix accidental discrimination or statistical imbalances. He argued that Section 2 must focus solely on the Constitution's ban on intentional discrimination under the 15th Amendment. Let me explain why this switch from impact to intent destroys the law. Proving intent is nearly impossible. Racist politicians don't usually hold press conferences saying, "I am drawing this map to hurt black voters." Instead, they hide behind partisanship. They say we drew this map to protect incumbents or to favor Republicans. Before LouisianaVCallais, if a map mathematically packed black voters into one district while spreading white voters across 5 others, a court could rule that the effect was racist. Now, according to the majority, if a state claims it was just being partisan and not racist, the court has to take their word for it. So what does this actually look like on the ground? It looks like a clean sweep. According to executive research from Democracy Docket, the LouisianaVCallais ruling has likely derailed at least 28 active lawsuits that were trying to stop racial discrimination in voting. We aren't talking about a small town controversy. We're talking about the future of Congress. Let's look at the dominoes falling in real time. Alabama. Remember the Allen versus Milligan case? Just 2 years ago, the Supreme Court actually protected a second majority black district there. That ruling is now in the trash. Legal experts expect Alabama to eliminate that black district immediately. Mississippi. The governor, Tate Reeves, literally scheduled a special session for May 20th, 3 weeks after this ruling, specifically to draw maps that dismantle minority representation, knowing the court won't stop him. And Georgia. Georgia challenges to the commission boards, dead. North Dakota, Native American tribes who just won a majority victory, now that's on life support. Nicholas Stephanopoulos, a Harvard law professor, put it bluntly, "It's there in theory, but no one will be able to win a claim under the provision. States can freely dismantle minority opportunity districts as long as they make clear they're doing so for partisan reasons." In other words, the Supreme Court has handed states a playbook. You want to eliminate a district that elects a person of color? Just say you want to help the Republican Party, not hurt black people. Let's zoom out for a second. This is the third time in 13 years the Roberts Courts has narrowed the VRA. It is a death by 1,000 cuts. The conservative legal movement has long argued for a colorblind constitution. They argued that the government shouldn't sort people by race, even to help them. John Yo, a conservative legal scholar, praised this ruling because it forces the government to obey that colorblind ideal. But the dissidents see this very differently. Justice Kagan, in one of the most scathing dissidents of her career, noted that the majority's ruling eviscerates the law, so it won't remedy even the classic example of voter dilution. Travis Crum, a law professor at Washington University described the current state of the Voting Rights Act with a simple, powerful word, moribund. That means close to death. The statute is still on the books. It still looks like a law, but functionally, it has no pulse. Where does this leave us? President Trump held the ruling as a victory. Republican-led states are already moving to redraw maps to lock in power for the next decade. Without Section 2, the federal government has almost no power to stop racial gerrymandering. The only remaining guardrail is the Department of Justice, but they have limited resources, and a single private citizen can no longer effectively sue to protect their own district. The Voting Rights Act of 1965 is effectively gone. It hasn't been repealed by Congress, but it has been dismantled by the courts. We are now entering a new era of American voting, one where the guardrails of the Civil Rights Act era are officially broken. The question isn't whether maps will be redrawn to dilute minority votes. The question is just how aggressive states will now be that they know no one is watching. Thanks for watching. If you have found this breakdown helpful, please like, share, subscribe, and hype up this video so that it gets out in the algorithm. I will see you in the next one. Until then, peace and blessings from the West Side. And I, of course, would love it if you would follow me on my other social media. You can find me over on TikTok and Instagram as DC the Purple Diva, over on X as Purple Diva Den, and you can catch me on my other YouTube channel, The Purple Diva Den, where I do spoken word. I'll see you guys in the next one. Bye for now.